Hello friends, in the series on income tax cases, today we will discuss a case in which the assessee filed the writ petition before the Honorable Kerala High Court, where the assessments were completed on the basis of reports of some officials like village officer and agriculture officer, and the assessee during the assessment proceeding asked the cross-examination of those officers who have prepared those reports, but the assessing officer denied the opportunity of cross-examination on the ground that since no statement has been recorded and those officials have worked only in their official capacity, that is why the opportunity of cross-examination should not be given. So the issue was that whether in that case also the cross-examination can be demanded by the assessee. And the second issue was that if assessing officer gives some time to the assessee to produce some person and the assessee asks some more time, but the assessing officer either do not reject that request or do not accept that request and denies to admit the witness on a date which is beyond the date which has been given by the assessing officer. So whether this approach of the assessing officer is against the principle of natural justice, these both the issues have been taken care by Kerala High Court in the case of a writ petition in the case of Roy Korean versus Principal Commissioner of Income Tax, and this case is reported in 188 taxman.com 67 and the date of the judgment is 17th June 2026. The present case relates to the assessment year 16-17 to assessment year 2023. In the present case there was a search on the assessee, and in that search some unaccounted cash was found in the premises of the assessee. When the assessment proceedings were going on, the assessee explained that this cash belongs to the agriculture income of the assessee which has been generated by growing the pineapples, and during the assessment proceedings the assessee also furnished the names of the 5 entities as buyers. During the assessment proceedings, the assessing officer said that the report of the village officer and the agriculture officer says that the land of the assessee is barren and no agriculture activity can be done on that land. So the assessing officer rejected the claim of the assessee that cash belonged to the agriculture activity of the assessee. When the show cause notice was issued to the assessee on this ground, the assessee said that the opportunity of cross-examination of the persons who have prepared those reports, on whose reports the assessee officer is relying, should be provided to the assessee. But the assessing officer rejected this request of the assessee of cross-examination on the ground that no statement of those persons have been recorded, and since those persons are just working in their official capacity, so the opportunity of cross-examination cannot be given. For this, the assessee said that because a negative view is taken against the assessee for those persons, so the opportunity of cross-examination should be given, but the assessing officer made the additions. And one point in this case was that the assessee was produced to those persons to whom the assessing officer has issued the notices, and those notices were unserved. Out of that 5 persons, the assessee produced 2 persons on 12th March 2024. But for remaining persons, the assessee produced 2 persons on 14th March 2024, but the assessing officer did not record their statement on the ground that they have not been produced on the date specified by the assessing officer, but the assessing officer either didn't consider their request for adjournment or not granted the adjournment. So the assessee challenged the assessment order on these 2 grounds in the writ petition, and when the court heard the matter, the court said that the opportunity of cross-examination is a vital part of principle of natural justice, and without giving the opportunity to cross-examine the person, the assessment cannot be completed. And so the court quashed the assessment proceedings on the ground that since the assessing officer is relying upon the report of 2 officers, so the assessee request should be considered or accepted by the assessing officer. And the court also said that the assessing officer neither rejected the request of the assessee to grant the time to the assessee to produce the witnesses. So in that case, the principle of natural justice has been violated, and on this ground the assessments were quashed and remanded the matter back to the assessing officer to do the reassessment. Friends, this case is very important because the revenue cannot make the addition just on the basis of some statements or on the basis of some reports which are not being confronted to the assessee, and those persons who have prepared those reports or the persons who have given those statements should be properly produced before the assessee for the cross examination. At the end of this video, once again I am repeating the name of the case. The name of the case is Roy Korean versus Principal Commissioner of Income Tax, and this case is reported in 188taxman.com, page 67, and the date of the judgment is 17th June 2026. Thank you, friends.